Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, a partner at the Immigration, Medical Malpractice, and Business Litigation law firm Kurzban, Tetzeli & Pratt, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Serenade eImmigration. My friends at eImmigration, the case management platform that simplifies immigration casework, have created an exclusive offer just for Immigration Review Podcast listeners. When you book a demo through the link in the show notes, get.eimmigration.com/IRP, they'll donate $25 to Casa Cornelia Law Center in San Diego on your behalf. Check out Casa Cornelia for all the good work they do, too. And that's not all. You can also receive a free upgrade to their Complete plan. It's a win for your practice and a win for a great cause. Visit get.eimmigration.com/IRP to learn more and book your demo today, or of course, click on the link in the show notes. This podcast is also sponsored by Gonzalez & Gonzalez Immigration Bonds. Immigration attorneys. Once you've secured a bond, let Gonzalez & Gonzalez take it from there. In business and family-owned for 75 years, Gonzalez & Gonzalez helps other families post immigration bonds quickly, easily, and with full support every step of the way. Sure, you can post directly with DHS, but that means no guidance, no help when something goes wrong, and a 4 to 6 month wait for a refund. With Gonzalez & Gonzalez, families get hands-on help throughout the entire process and typically get refunds within 1 to 2 weeks of receiving the I-391 notice. Tired of being the point of contact for every bond question? Let Gonzalez & Gonzalez take those calls. They'll handle the paperwork, the system issues, and the family's concerns, so you can focus on what really matters, winning the case and helping your clients stay in the country. You can reach Gonzalez & Gonzalez at 833-409-9200. Their fee? Just 2% plus $40, and for bonds of $10,000 or more, they can defer the fee and deduct it from the refund. Financing options? They've got those too. Give Gonzalez & Gonzalez a call, check them out at immigrationbond.com, or click on their special link in the show notes. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Greetings. This week, the Ninth Circuit, on Thursday, ruled that President Donald Trump likely has the authority to suspend admissions of people seeking refugee status in the United States, but said that the government's defunding of services to refugees already admitted is likely unlawful. Then late Friday, a different Ninth Circuit panel temporarily stayed the Maldonado-Batista decision outside of the Central District of California. But who knows, there will probably be further updates on that by the time the millions of you out there listening listen. Billions, really. I have the stats. Something else happened this week in immigration world, but what was it? Oh yes! Kristi Noem is Noem Moore at DHS. You like that? I mean, she still exists, and now she has some weird made-up title within the U.S. government, but she's out. Seems like the last straw was implicating the president in a $200 million corrupt contract before the U.S. Senate. Not gonna lie, I'm surprised that was his line, but whatever. From Heather Cox Richardson's daily Substack, quote, apparently unaware she was fired, Noem proceeded to give a speech in which she recited a false quotation from George Orwell, the writer who devoted much of his work to the importance of manipulating language to facilitate authoritarianism, a fitting end to Noem's career in the Trump administration, end quote. Can't make this stuff up. In her place will be nominated Oklahoma Senator Mark Wayne Mullen, who, say whatever else you want to say about him, and much has already been said, but I'm going to enjoy saying his name on the podcast. Rolls right off the tongue, Mark Wayne Mullen. Can't get enough. Also this week, a split D.C. circuit denied the government's emergency stay in our Haiti TPS case. 100,000 Haitians remain safe. For now. And finally, friend of the podcast, Nicholas Perry, who we did a special episode interview with a couple of months ago, has finally opened his firm. Check out perryimmigrationlaw.com. Recall, Nick Perry is a former senior attorney at USCIS, the State Department, the DHS Office of the General Counsel, and ICE. And he's bringing his insider experience to individuals and attorneys navigating complex immigration matters. He's also very open to contract and consulting work. PerryImmigrationLaw.com. As to me, well, we've got 5 cases this week, and they are pretty wonky. Jurisdictions, standards of review, all over the place. But they're very important, and I don't make up the decisions. And so, here they are. Starting off, because those are the rules, we go to the U.S. Supreme Court with Urias-Orellana v. Bondi, published by the court on March 4th, 2026. This case is about standards of review. It's issued by a unanimous court and affirms the First Circuit's decision in this case from episode 238. Most importantly for Supreme Court season, it's only 13 pages. Justice Jackson delivered the opinion. The case is about a family of asylum seekers from El Salvador who entered the United States without authorization in 2021. They sought asylum in the Boston Immigration Court, but they lost. The husband was the sole witness, and he testified that a hitman in his hometown had been targeting him since 2016. The Sicario, as such people are known, had already shot 2 of his half-brothers and vowed to kill every member of the Urias-Orellana family. Mr. Urias-Orellana and his wife and child therefore relocated within El Salvador many times, but each time, Mr. Urias-Orellana was threatened by men demanding money and threatening to shoot him like they'd shot his brothers if he didn't pay. One of the men even physically assaulted Mr. Urias-Orellana on one occasion when he went back to his hometown. The last straw came, explains the Supreme Court, when Mr. Urias-Orellana learned that men had been asking around town for him or new arrivals in their 4th town of relocation. They then fled El Salvador for the United States. Mr. Urias-Orellana was deemed credible by the immigration judge, but the IJ just didn't think all of it bad enough to be past persecution. As we'll hear later this show, a past persecution finding is of course quite important for such cases, as it gives DHS the burden to establish that the non-citizen does not warrant asylum. Now, death threats seem to be the main harm here, and First Circuit precedent holds that death threats may establish past persecution when they are, quote, so menacing as to cause significant actual suffering or harm, end quote. The IJ reasoned that Mr. Urias-Orellana had failed to so establish because he hadn't, quote, submitted any medical, psychiatric, or psychological evaluations indicating that he'd experienced such suffering or harm, end quote. Plus, the IJ reasoned that the relocations were kind of successful. The BIA affirmed the no past persecution finding and no well-founded fear finding for the future, given that the major problems only really happened in the hometown. And then the First Circuit affirmed that on episode 238. Now, importantly, everyone, it was not in dispute before the First Circuit that, quote, death threats may establish past persecution only when they are so menacing as to cause significant actual suffering or harm, end quote. The Supreme Court certainly doesn't make that holding, and so that's not even dicta, really. I see nothing from this decision limiting death threat case law from other circuits. Indeed, the Supreme Court makes this quite clear in footnote 1. But that is the standard governing this case. The substandard, really, because this decision is simply about Circuit and Supreme Court standards of review for past persecution claims. Mr. Urias-Orellana was, of course, arguing that past persecution is a mixed question of law and fact, a la Wilkinson and Guerro-Lasprila, and so is subject to de novo review. After all, it is kind of, right? Assuming that everyone agrees about what happened to Mr. Urias-Orellana factually, whether those facts equate to the legal definition of past persecution would seem to be a classic mixed question of law and fact. Not so, explains the Supreme Court. I&A Section 242b4b, for example, states that, quote, administrative findings of fact are conclusive unless any reasonable adjudicator would be compelled to conclude to the contrary, end quote. That, explains the court, smells like substantial evidence review, and the court has so held before. Still begs the question, though, what happens when the question isn't really factual? No one seems to be arguing about here what happened to Mr. Urias-Orellana, but rather the legal implications. Other circuits have split the reviews, specifically the 2nd, 3rd, 5th, 8th, 9th, and 11th. With past persecution, they have applied substantial evidence review to the fact-finding and de novo for whether it is persecution. Although even those courts had some confused decisions intra-circuit, explains the Supreme Court. Anyway, no longer holds the court. It's all substantial evidence review. Contrary decisions from those circuits, or really any, are abrogated. Substantial evidence review means that the IJ, or I suppose the BIA's factual finding, are upheld by the circuit unless, quote, any reasonable adjudicator would be compelled to conclude to the contrary, end quote. The Supreme Court believes that all of this follows from its seminal asylum decision in Urias-Orellana from many decades ago, where, the court explains, the Supreme Court did exactly that, applied substantial evidence review to the whole shebang. Now, of course, much has changed since Urias-Orellana, including, of course, the publication of Guerro-Lasprila and Wilkinson, and the nuanced review required of mixed questions of law and fact under the INA. Well, the court does get into that in the final paragraph. Those decisions concerned INA Section 242A's otherwise total bar on judicial review. This decision here depends on INA Section 242B, and despite not actually saying the words substantial evidence, that statute speaks to the standard of review in a manner that the court says equates to substantial evidence. Ultimately, the court reads IRIRA as doing all it can to limit the ability of federal courts to review things, so it makes little sense to the court for there to be a de novo carve-out for a portion of a past persecution finding. Beware this decision and other mixed question of law and fact cases that have not yet been settled by the Supreme Court, and especially in the asylum realm. We get into that more now. 2 things. First, and tell me if you read this differently, but I believe this court just answered the budding post-Wilkinson question, what standard of review to apply to mixed questions of law and fact of non-LPR cancellation hardship. It's reviewable post-Wilkinson, sure, but the circuits have been trying to figure out under what standard of review. Seems like it's substantial evidence now, which is of course what all the circuits seem to have been saying, although I do seem to recall an abuse of discretion decision out of one of the courts. Quote, whether a given issue is treated as a question of law exempt from the INA's jurisdiction stripping provisions tells us nothing about the type of review the court must afford to that issue under other provisions of the statute, end quote. And if past persecution is substantial evidence, why wouldn't all the relief mixed questions of law and fact be substantial evidence rather than de novo? Devastating if true. Email me if you disagree. I do not want to be right about that. And finally, I believe there's still at least one way to get de novo review of a past persecution finding, and it would certainly align with the current law everywhere. The Supreme Court states, quote, the INA's legal standard for persecution must be applied to the IJ's findings of fact, end quote. So if you argue that the BIA applied an incorrect persecution legal standard, well, that should be a legal question reviewed de novo by a circuit, even with this Supreme Court decision. And that is Urias-Orellana v. Bondi. Picture this. It's 10 p.m. on a Friday. You finally sit down to dinner when your phone rings. A panicked client just received a USCIS denial and has no idea what to do. And you answer because that is what immigration lawyers do. The truth is, you don't have to be the one answering every single time. Staffy Live gives you 24/7 bilingual intake specialists who handle those urgent calls with the same empathy, precision, and professionalism that your clients expect from you. And with Staffy Outsourcing, the casework that absorbs your nights and weekends disappears from your plate. Document collection, forms, evidence, packages. They prepare everything. All you do is review and submit to USCIS. I-130s, I-45s, waivers, adjustments, and more than 18 additional immigration case types. Staffy's team handles the workload so you can focus on the legal strategy that only attorneys can provide. Hundreds of immigration attorneys already use Staffy Live and Staffy Outsourcing to reclaim their evenings, their weekends, and their peace of mind without sacrificing client care. And right now, Your first 3 cases are free when you get started. Visit staffy.cc or call 786-891-5619 or click on that special link in the show notes. Because you deserve a practice that grows without burning you out. Next is Ortez Reyes v. USCIS, published by the 4th Circuit on March 5th, 2026. This case is about jurisdiction. Always riveting, and quite important, and a minefield post-Patel. Mr. Ortez is from Honduras and received asylee status in America. He's been married to his wife, Miss Estrada, for 20 years. But Miss Estrada was previously removed from the United States in 2014. They actually came together in 2020, it seems, but Miss Estrada had been here previously. Mr. Ortez got asylum, but it seems DHS reinstated Miss Estrada's removal order, making her only potentially eligible for withholding of removal or Convention Against Torture protection. An immigration judge denied Miss Estrada's separate claims there, and that matter remains pending before the BIA. In the meantime, however, Mr. Ortez filed a Form I-730 for Miss Estrada, seeking to make her a derivative asylee because she is his wife. The USCIS denied that petition, believing that the reinstatement statute at INA Section 241A5 bars approval of I-730s for non-citizens with prior removal orders. That, my friends, is what Mr. Ortez sued about in federal district court. The district court, however, held that it lacked jurisdiction to review the question, relying on INA Section 242A2Bii. That statute holds that, quote, no court shall have jurisdiction to review any decision or action of the Attorney General or Secretary of Homeland Security, the authority for which is specified under this subchapter, to be in the discretion of the Attorney General or the Secretary of Homeland Security, end quote. An I-730 is discretionary, reasoned the district court, so it lacked jurisdiction over the lawsuit. The Fourth Circuit disagrees. The companion provision of INA Section 242A2B single I was recently adjudicated by the Supreme Court in Buarfa, not to mention Patel. In those decisions, the court held that even factual questions are barred from review when review of the ultimate grant of relief would also be barred. To paraphrase some very complicated decisions. And the Fourth Circuit has applied that rationale to subsection II USCIS adjudications from district court as well. But what about when USCIS's relief denial depends solely on their interpretation of the INA, like a pure legal question? Not barred from a district court lawsuit, said the court. Quote, pure decisions of law, such as the one at issue here, fall outside the scope of Section 242A2Bii's command, end quote. This isn't like the Fourth Circuit's 2024 Shebine decision from episode 206, where in addition to a legal question, there was a factual dispute over whether terrorist activity had been committed at all. This is a pure legal question. Must I-730s be denied where the non-citizen is subject to a removal order? That is entirely separate from any of the recent case law barring review of immigration things in federal court, explains the federal court. And even Patel wasn't a pure legal question. In addition to being an immigration court dispute, Mr. Patel's credibility was also in dispute. So this is an important case for distinguishing getting federal court review of many USCIS denials, including adjustment of status, I'd think, if based on a pure legal question. So, can a non-citizen with a final order of removal that I suppose has been reinstated obtain derivative asylee status? Going back to the district court to find out. Big, important remand. This. Meaning congratulations, Joseph David Moravec for appellant. And that is Ortez Reyes, the USCIS. Now I got to get through 2 from the BIA. First, matter of DJL, published by the BIA. The BIA continues its assault on my expert witness arguments. Well played, BIA. I mean, kind of. I'd hope my expert wouldn't testify as such, but also I'm not confident that the BIA is always accurately summarizing the factual record in these decisions. This matter was remanded by the old BIA for further Convention Against Torture consideration. The new BIA is very different. Now it's not happy that the IJ granted cat protection on remand. So Mr. DJL is going to what is widely regarded as one of the worst places on Earth not subject to a literal active war, which I admit is an expanding qualification. He's going to Haiti. Mr. DJL, not DJT, fears that as a criminal deportee who suffers from mental illness, he will be subject to indefinite detention upon removal to Haiti, while suffering deteriorating mental illness because of the conditions in detention and lack of medical care, and will be personally targeted for torture by Haitian government officials. The applicant also fears that he will be targeted and tortured by criminal gangs with the acquiescence of the Haitian government. The BIA hates claims like this, and has made that quite clear over the last year. Doesn't make them right, but they've definitely shown a trend. Haitians in particular, it sometimes seems. The IJ didn't hate it and granted protection. In doing so, the IJ relied on the testimony of, quote, the founder and executive director of a nonprofit organization that assists deportees in Haiti, end quote. The IJ qualified that individual as an expert on Haiti and relied on her opinions. The BIA doesn't like that. What is an expert? Well, quoting Federal Rule of Evidence 702, the BIA explains that it's someone, quote, who by knowledge, skill, experience, training, or education has scientific, technical, or other specialized knowledge that will help the trier of fact to understand the evidence or to determine a fact at issue, end quote. But, stating for the first time, the BIA holds that, quote, nothing requires an immigration judge to give special consideration to the testimony or declaration of an expert witness, end quote. Which isn't generally how experts work in federal and state court, I think. Expert testimony is pretty important. The BIA reminds that an IJ should only find experts' opinions persuasive, quote, if there is a reliable, factual, or evidentiary basis for the expert's conclusions, end quote. Now, the BIA concedes that this person is an expert. It just doesn't like the weight given to her testimony. Pretty wild for an appellate body. Here, the expert has an advocacy background. Nothing like the people currently running DOJ and DHS, of course. And at one point, this expert believed that the U.S. should stop removing people to Haiti, including criminal deportees, given conditions in that country. Can you imagine the audacity? It's too biased for the BIA. The testimony is admissible, but, quote, where an expert witness's background and testimony reflect a reluctance to consider contrary evidence and an inability to impartially assess matters involving the removal of persons to a given country, an immigration judge errs in giving the testimony of that witness significant weight, end quote. Quite a few qualifiers in that sentence, though, so prepare your experts appropriately. Applied here, this made the expert insufficiently reliable to the BIA. I'll stop to note that none of this is actual Convention Against Torture analysis, and seems to be more akin to classic reweighing of evidence that counsel should certainly consider a petition for review of. But having disposed with the expert, the BIA then applied de novo review to vacate the CAT grant. After all, it keeps holding that even indefinite detention in Haiti, and of Haitian criminal deportees in particular, does not warrant CAT. To the extent people are dying and being treated horribly in those prisons in Haiti, well, those are just some poor, unfortunate souls. Quote, a relatively small number of anecdotal incidents, end quote, that the BIA is very much willing to live with. The BIA time and again faults the IJ for relying on the certified expert's opinions for lacking corroborating evidence, thereby begging the question to me what the BIA believes the point of an expert is, given, after all, that expert opinion is evidence. When qualified as an expert, of course. Candidly, the BIA probably does wish that experts did not exist in immigration court, and so here we are. Now, Mr. DJL also submitted a reply brief on appeal, surely because his attorney cares very much about him. And with that brief is an April 2025 article after the IJ ruled, stating, among other things, that, quote, the United Nations can no longer provide financial assistance to all deportees in Haiti because of funding cuts, end quote. Believing that new evidence insufficient to change its mind, the BIA ordered Mr. DJL removed to Haiti, where, by its own concession, he may face indefinite detention in truly horrible conditions. And I continue to wait for the fact pattern that this BIA believes deserving of CAT protection. I do have a final thought, though. To get here, the BIA noted Attorney General Barr's decision for matter of RAF, that the BIA reviews whether the facts of a case meet the legal definition of torture de novo, given that it is all a mixed question of law and fact. And maybe so still, given that CAT is a creature of regulation and not the INA. Maybe. But I wonder what effect the Supreme Court's decision this week that I just did has on other BIA and Attorney General holdings of late expanding de novo review to overturn IJ mixed questions. I think de novo review of past persecution findings is out, no? To be litigated. It's got me thinking. And that is matter of DJL. Continuing with matter of RBE, which the BIA was kind enough to give us on Friday afternoon. The AAO actually also got in on the action too, but I will do that decision next week or whenever it's slow, as it is Friday, and I just spent a long time at an asylum interview. This decision is about the past persecution rebuttable presumption. Waiting with bated breath on how the BIA is about to make that bad for non-citizens too. Let's begin. An immigration judge granted withholding of removal, and naturally, the BIA has reversed that on DHS's appeal. And again, we have a Haitian individual. Miss RBE suffered past persecution in 1999 and 2000 because her family opposed the Lavalas government led by former President Aristide. That's what an immigration judge found. And so Miss RBE got asylum in 2004. But she never adjusted to LPR status and never naturalized, which was a big mistake, and in 2020 she was convicted of conspiracy to commit access device fraud pursuant to 18 U.S.C. section 1029b2. No one's arguing that the conviction isn't an aggravated felony, and so Miss RBE was barred from asylum. But an immigration judge granted withholding. The BIA reversed that. Now, recall, for withholding and asylum, a non-citizen who has suffered past persecution benefits from a rebuttable presumption that they'd suffer future persecution if removed. DHS then has the burden to establish that relocation is reasonable or that a fundamental change in circumstances has occurred in that country. DHS argued here that it met the latter, and the BIA agreed. The Lavalas, after all, are no longer in power, and Miss RBE's case is all about her political opposition to them and her families. Also, quote, the respondent last resided in Haiti in 2000, and the record contains no evidence that she remains of interest to any political group due to her family's prior political activity, end quote. Now, Ms. RBE argued and apparently provided evidence to support that the Tet Kale party is aligned with the violent gangs that kind of control Haiti now, and that the party is a continuation of the Lavalas party, and that she opposes the Tet Kale party. The BIA disagreed. Although important for all of your other Haiti cases, quote, the immigration judge did not clearly err in finding widespread gang violence in Haiti, end quote. But the BIA just doesn't see a record showing that the gangs are really linked to a political affiliation, rather than just kind of indiscriminately creating hell on earth for everyone in Haiti at present. And now for a sentence that I had to read multiple times, given the weird burden shifting going on therein, quote, where a presumption of a future threat to life or freedom applies, an immigration judge cannot rely on generalized crime and widespread violence unrelated to the original claim to find the presumption has not been rebutted, particularly where other evidence suggests a fundamental change in circumstances such that a respondent will no longer be harmed on account of a protected ground, end quote. Point taken, I think. That said, very little discussion, nay, none really, about what evidence DHS submitted to meet its burden. Things do get quite mushy these days with BIA decisions where DHS actually has the burden. This despite the fact that, quote, the record describes a catastrophic security situation in Haiti driven by criminal gangs and institutional collapse, end quote. Again, important for your other Haiti cases, but not really political to the BIA, so not very helpful to Miss RBE here, even though DHS has the burden. Without the presumption, the BIA doesn't believe that Miss RBE showed sufficiently a clear probability that she herself would be singled out for persecution. Remember, we're in withholding land. The IJ's heavy reliance on country condition reports, God forbid, are insufficient to the BIA. Plus, it seems that Miss RBE has family there that remain unharmed. Important it seems because I think her initial Lavalas claimed was partially family-based, at least as described by the BIA. With that matter disposed of, but unsatisfied, the BIA goes on to find that actually, the conspiracy to commit access device fraud in violation of 18 U.S.C. section 1029b2 constitutes a particularly serious crime, rendering Ms. RBE statutorily ineligible for withholding of removal anyway. So here's an example that I could have used in my Barry oral argument that yes, the BIA will reach legal issues that it doesn't have to in its decisions. Important to remember when you're before a circuit and the circuit wants to remand to the BIA to give it another chance to address something it hadn't addressed sufficiently before. Specifically, the statute of conviction criminalizes knowingly and with the intent to defraud trafficking in or using one or more unauthorized access devices to obtain $1,000 or more during a 1-year period. That's the type of special crime that's so serious that it's the type that it can be particularly serious? Of all the crimes in the world, remember, by definition, a matter of NAM is analyzing the criminal elements at the first stage. It is, said the BIA. Literally no explanation of that, though. Just a conclusory sentence. Quote, here, the nature of the respondent's conviction, which involves conspiring, through fraud, to obtain money through the use of unauthorized access devices, brings it within the ambit of a particularly serious crime. End quote. Literally just repeating the statute. Having jumped the hurdle, though, the BIA went to the facts and concluded that they showed that it was quite serious, overturning the IJ here, too. Doesn't matter to the BIA that Ms. RBE cooperated with the government, as the IJ believed was important. Quote, cooperation with law enforcement authorities is a factor subsequent and unrelated to the commission of the offense, which may operate to reduce a sentence, but does not diminish the gravity of a crime. End quote. Also, and although I was led to believe that a wide swath of factors were relevant to the second and third prongs of NAM, the BIA also states that the IJ was wrong to believe that Ms. RBE, quote, was not certain of her co-conspirators' intentions in obtaining the information, end quote, given that she pled to a culpable mens rea offense. Getting to the meat of it, the BIA can't get past the fact that it sees a scheme where Ms. RBE abused her position as an insurance sales agent to help a criminal act that resulted in loss in the millions of dollars. Quote, identity theft by its nature is an especially damaging method of theft, end quote. So she was barred from withholding of removal anyway, explains the BIA. So why do that whole past persecution rebuttable presumption analysis? It is so curious. The BIA didn't actually ensure that Ms. RBE gets removed to Haiti and instead remanded for further Convention Against Torture deferral analysis. Meaning that the particularly serious crime analysis was important because it takes away cat withholding, but again, all of that past persecution analysis and the rebuttable presumption stuff seems completely unnecessary. Throwing shade on her credibility, the BIA remanded for further proceedings. And that is a matter of RBE. Elevate your advocacy and storytelling skills at the annual Immigration Court Trial Advocacy College. Registration is now open. The annual Immigration Court Trial Advocacy College convenes every year in April, only in Kansas City, Missouri, hosted by the Pen and Sword, that awesome community resource founded by Reka and Michael Sharma Crawford. This year, the program has been reimagined and reworked to address the current climate of aggressive deportation enforcement. These times are not ordinary, so the program had to be extraordinary. Expanding from 3 to 4 days, the Trial College provides comprehensive training from beginning to end, real cases taught by real litigators in real courtrooms. The skills you need, the confidence you deserve, and the mentors you look up to, all in one place. Register early to avoid disappointment at www.thepen-and-swordkc.org or at the special links in the show notes. Use special code ImmigrationReview26 to get $50 off the Trial Advocacy College this year. That's capital I, capital R. Not sure what to do when a client asks you about the EB-5 investor visa or how they can choose the right EB-5 project? That's where EB-5 support comes in. Founded and led by veteran immigration attorney Irina Rostova, EB-5 Support helps investors navigate the entire process of EB-5 project selection and provides complimentary training for immigration attorneys who want to strengthen their EB-5 petition filing skills. Visit eb5support.com. That's eb-5support.com. Or click on the link in the show notes. Access their online attorney portal for training tools and practical resources, or schedule a time to speak with the team. All project guidance is provided by FINRA-registered financial professionals, so you and your clients can proceed with confidence. EB-5 Support, where immigration law meets investment expertise. Securities offered through Sequence Financial Specialists. Doing business as Invest America. We conclude with Reyes v. USCIS, published by the Ninth Circuit on March 5th, 2026. This case shows how I&A Section 242A2Bii can very much go the other way in bar jurisdiction as compared to the Fourth Circuit decision that we did earlier in the show. This is a dense and long read. I'm going to try not to get bogged down in it, but I cannot promise anything. Mr. Reyes applied for and appears to be eligible for a U visa because he was the victim of a crime and helped law enforcement. However, like many U visa applicants, but of course not all, he's also inadmissible, meaning he can't get the U non-immigrant status unless he gets granted an I&A Section 212D14 waiver. Mr. Reyes is inadmissible because he was in the U.S. without authorization for over a year, and then he left, and then he came back unlawfully. The permanent bar, under I&A Section 212A9C. Thank you, Ira. Also, it seems like he was removed and might even have a controlled substance conviction, so there you go. All waivable, though, in the context of a U visa, if USCIS so chooses, in its discretion. USCIS did not so choose, and actually it denied the U visa based on an inadmissibility finding without even getting to the pending waiver. How fun, USCIS! How do you explain that to your client who paid you based on your advice that you could file a waiver? When Mr. Reyes appealed, USCIS denied the waiver. How fun. Mr. Reyes then sued in federal court, but a district court judge dismissed for, you guessed it, lack of jurisdiction. And the Ninth Circuit affirmed. Recall what I&A Section 242A2Bii says. Recall, I say, quote, no court shall have jurisdiction to review any decision or action, the authority for which is specified under this subchapter to be in the discretion of the Attorney General or the Secretary of Homeland Security, end quote. Now, while the APA, the Administrative Procedure Act, generally permits federal lawsuits against agency action or inaction, 5 U.S.C. Section 701A holds that APA review does not apply where another statute precludes review, or where, quote, agency action is committed to agency discretion by law, end quote. The interplay between this and the I&A is complicated, and the Ninth Circuit goes through it for a few pages. But at the end of the day, it comes down to the waiver statute at Section 242A2Bii. The waiver statute at Section 212D14 permits a waiver grant, but it's totally discretionary. No one can really argue that. It's mush, really. Quote, the Secretary of Homeland Security and the Secretary's discretion may waive conditions of inadmissibility in the case of a non-immigrant seeking a U visa if the Secretary considers it to be in the public or national interest to do so, end quote. And let me tell you, based on her position in the Haiti TPS case, I'd say that former DHS Secretary Noem doesn't believe it's in the public interest to have many non-citizens, and maybe take out the M. Of course, USCIS isn't Miss Noem. I'm just being petty. But in any event, the waiver is clearly very discretionary, reasons the Ninth Circuit. And it's similar to other waivers that the Ninth Circuit has deemed discretionary and so precluded review of post-Patel. Seems like Mr. Reyes put his eggs in the basket of that latter mush phrase, arguing that, quote, the public or national interest is a judicially manageable standard of review, end quote. But it's not, explains the court. Or that is, it's not sufficient to get over the I&A's jurisdiction stripping provision hurdle. It's pretty bad for non-citizens going forward. There's been some good law in the Ninth Circuit on all of that since 2003 and 2004, largely based on a case called ANA International v. Way, holding that where there appears to be a legal standard within an otherwise unreviewable statute, the court might have jurisdiction. To simplify things. Not anymore, though. Post-Boarfa, the Ninth Circuit believes A&A International no longer good law. Boarfa actually apparently targeted A&A International itself expressly, so there you go. Now, quote, when Congress signals that it is merely providing guidance to the agency on its exercise of discretion, the discretionary judgment call as a whole falls within the jurisdiction stripping provision at I&A Section 242A2Bii, end quote. Tough stuff, litigators. The court is clear, however, that this is different from where, say, the agency has discretion, but only if certain statutory elements are met. An agency's error on those statutory elements still might be reviewable. But that's not what's happening here. There's no threshold-type statutory requirements here, and so, like Boarfa, this is discretionary mush that's unreviewable, explains the Ninth Circuit, not using the word mush. With A&A International overruled, quote, going forward in a case brought in district court under the APA, if a clause provides only guidance to the agency on its exercise of discretion, then that guidance is part of the exercise of discretion and falls within I&A Section 242A2Bii, end quote. And as we all feared post-Patel, because this is district court jurisdiction rather than circuit court petition for review, the jurisdictional savings clause at I&A Section 242A2D can't come in to save anything because it's directed only at circuits on petition for review, as Justice Barrett herself recognized towards the end of Patel. Realizing he was in trouble, Mr. Baracharaz's dedicated counsel argued that this whole scheme is unconstitutional because it entirely cuts off judicial review. But Congress can give reduced procedural rights to non-citizens. Patel said that. The Ninth Circuit relays. That reduced right here is that Mr. Baracharaz can eventually get federal court review. He just has to get put in removal proceedings, go through an IJ in the BIA, and then get to the circuit on petition for review. Never mind that I don't think he can actually get granted a U visa waiver, although maybe in the 11th Circuit. Actually, definitely in the 4th and the 7th Circuit, notes the 9th Circuit in a footnote. An IJ can grant a U visa waiver in those circuits. The court seems to be saying something more nuanced, that to the extent Mr. Baracharaz believes this all unconstitutional, he can present that claim on petition for review, after going through the whole process I just described, which is, of course, wild. But so is Herrera. Also, hey, maybe he'll get other relief in removal proceedings, reasons the court. And in any event, the Ninth Circuit kind of just said the same thing in Cabello-Garcia v. USCIS, episode 274. Rejecting a few other things, the Ninth Circuit affirmed the district court's dismissal. Judge Bea concurred to note that there is an intra-circuit split about whether actually the I&A's jurisdiction stripping provisions bar all constitutional claims against USCIS from being brought in district court, which is a truly wild thing, but I will concede, far from an irrational thing to believe, given the I&A's statutes and Patel. Judge Bea wants the Ninth Circuit to go en banc. For another day. And that wasn't a short summary at all. And that is Baracharaz v. USCIS. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. And we're always interested in hearing listener feedback. Like this review about the episode you just listened to from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next week for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.